Welcome back to the Environmental Law Monitor. I'm your host, Daniel Pope. This podcast is brought to you by Bracewell LLP. Today, we've had a conversation with Chad Whiteman of the United States Chamber of Commerce Global Energy Institute about the new Phase 2 regulations that the Council on Environmental Quality promulgated that changes the NEPA review process. That's the National Environmental Policy Act review process that requires agencies to take a hard look at the environmental impacts of their actions. And that can be an agency action, like the agency is authorizing a project or in some cases undertaking one of their own. These Phase 2 regulations are very significant in the changes that they make to the NEPA process. And those changes, large and small, will have an effect on industry, on companies, on the regulated community. And Chad Whiteman is so helpful for us to understanding what those impacts might look like. So we're excited to bring him on. He's joined by Ann Navaro, a partner in our DC office who regularly practices in the NEPA space. Thanks for tuning in. Chad, thanks for being with Ann and me this morning. One of the things I've come to appreciate about talking with you in particular about NEPA and especially about these Phase 2 regulations is the insight you provide to us about how changes to NEPA have real world impacts on projects, on the regulated community. Ann and I can always get really interested in the details and CEQ changed this about NEPA. Oh, and they changed this. This is a big tweak. This is a small change. And we're regulatory lawyers. That's what we do. We get excited about those things. We're interested in the trees, but it's so helpful to have you in conversation to help us step back and see the forest, right? So I think of today as a kind of a forest conversation. I imagine most of our listeners can Google around and find very, very minute summaries of what the Phase 2 regs change, but like help us to see how these Phase 2 regulations are going to land in the regulated community.
Happy to do that. And Daniel and Ann, great to be here. And the forest, we want it to grow. We want it to be healthy. And I think what we've seen is some tremendous investments that in infrastructure that can really help our economy to help all parts of our communities really grow and thrive. And to get all this infrastructure out there and built, a lot of it needs to go through the permitting process. So that's the nexus. But let me just explain a little bit about how big this once in a generation investments, how big they really are, because the opportunity is big. There's something close to $2 trillion in investments that Congress has recently invested in through grants and loans and tax incentives for transportation infrastructure projects, for semiconductor manufacturing, and also for, under the Inflation Reduction Act, a lot of clean energy projects. So we have almost $2 trillion out there. And in order to get these projects going, a lot of them have to go through NEPA. And if that process is long and delayed, it really has an impact on whether we can get these things done and make that forest strong and continue to grow.
Thinking about those kind of infrastructure investments, I'm also thinking about the bridge in Baltimore that collapsed. We've got sort of a backwards looking infrastructure need and a forwards looking infrastructure need, right? And so there's a lot of things that we need to be doing to rehabilitate or upgrade existing infrastructure, and then also to develop new infrastructure that meets and addresses new needs. And so it really kind of creates a couple of kinds of problems where on the one hand, we're exposed to potential collapses of infrastructure or existing reliability. And then we're also trying to grow as an economy.
That's right. And a lot of it's about investment, right? And continuing to grow our economy, continuing to attract that investment. The infrastructure bill really was trying to get at some of these things you're saying, the legacy infrastructure that was built decades ago, 45,000 bridges that DOT said need to be repaired, or they're close to 200,000 miles of roads, those sort of things. But looking forward, some of the big things are, look at the power sector, for example. The demand for energy has been pretty flat the last couple of decades. We've had increases in the population, but there have been helpful increases in the efficiency and the use of that energy. But now we're getting to the point where we're having this exponential growth due to things like data centers. The interesting factoid on that, ChatGPT search takes 25 times more energy than a Google search, right?
Wow.
You wouldn't think about that. But That's a lot, right? So with the growing interest in AI and use of AI, cryptocurrency and other things growing, these data centers have a really hungry demand. That demand's expected to triple in the next just few years. Adding on top of that, we have really interesting policy changes where we're trying to electrify light duty and heavy duty vehicles, electrifying buildings and appliances. So you're adding even more load on top of what does that mean though? What does that mean for permitting? Well, it means that we need to build a lot of transmission lines and new power plants, utility scale solar and wind and natural gas pipelines and hydrogen and all these things. And a lot of it has to go through permitting. Especially these interstate linear projects are really, really challenging. So that sort of brings us back. We have all this investment. We have all this demand for these new things. We want this economy to grow. One of the bumps in the road that we're hitting is permitting. So
it's an interesting time when you juxtapose those very significant investments and the desire to drive those projects forward to grow the economy and fix aging infrastructure, and then juxtapose it with the new NEPA rule, where the administration is also trying to advance some of its policy goals, but in a way that is likely to slow down permitting and create more complicated litigation for many of those same projects as agencies adjust to this new rule, which is dramatically changed, and as courts, frankly, grapple with some of the new requirements.
That's right. And I think that's one of our primary concerns with the rulemaking is there are so many new requirements, action-forcing requirements, shifting NEPA from a procedural statute to one that's requiring agencies to fulfill certain obligations and requirements that ultimately are going to take some time to work out. There's a lot of uncertainty in some of these subjective requirements. And if that leads to additional litigation, if that leads to longer environmental documents, those things just add to the delays. And at a time where we're trying to get a lot of these things on the ground and then the clock is ticking on environmental and economic investments, it's a real disincentive if the permitting process is more complicated, more cumbersome.
And so, Chad, what are some of the real sticking points? I mean, there are so many changes in this rule. When you compare the phase 2 rule to what came before, there are just a lot of little tweaks, a lot of new big changes. And so in terms of what's new, what's altered, what are some of the real sticking points from the regulated community that you're hearing from industry? Yeah,
I think one of the areas is just this whole shift in making NEPA an action-forcing statute. NEPA has always been the procedural statute where agencies look at the environmental impacts, take a hard look at those, and hasn't compelled them to take action to mitigate or reduce or avoid any of these actions. It really just helps them in the decision-making process when they're looking at alternatives. But there's been a real shift, a real turn here in making NEPA this action-forcing statute. There's language in there about agencies shall do this and shall do that and avoid this and reduce that. And that's a major shift. In all of the years that NEPA has been litigated, I think there's been this, certainly certain groups have been in favor of that and support that. But I think the way things have been set up and run for so long, it hasn't had that action-forcing. It's been very much more of a procedural statute. So that's a big shift.
And you have made this comment before and some of our conversations that almost the great benefit of NEPA is a sort of trust the process value or virtue that by undertaking these types of reviews, the agencies will learn meaningful information and will be able to, over time, really develop expertise in reducing environmental impacts, and that the regulated community, through having a standard set of procedures and predictable processes for reviewing impacts, will develop their own expertise. And then on the whole, project after project after project, both the government and the regulated community will reduce environmental impacts.
Well, and I think that's absolutely what NEPA has done. I mean, in my view, NEPA has been a wildly successful statute in terms of making sure that environmental considerations have a seat at the table along with other compelling considerations that agencies have to take into account. That was the intention, of course, because at the time NEPA was enacted, environmental considerations, I don't know that they were even at the kids' table. I mean, they were out in the backyard, like having takeout or something at the holiday celebrations. So NEPA brought environmental considerations to the table. And my sense from the phase 2 rule and the phase 1 rule is that in some quarters, folks are frustrated because agencies aren't making the decisions that they want and that advance particular policy goals. And so they're frustrated. They see NEPA as maybe not being much better than words on paper. I don't agree with that, but I think that sense of frustration has led to some of the changes that we've seen in the phase 2 rule. And recall from the phase 1 rule in the preamble where there was this notion that folks should be able to use NEPA to create desired conditions on the landscape, which kind of was never the intention of NEPA itself. So I do agree with Chad that this phase 2 rule has in many respects gone well beyond what NEPA was intended to be.
So when do agencies need to begin complying with the new rule? And what are the next steps for those agencies? You both have alluded to, I think, what is a big problem we'll take up here in a little bit, which is that there are some new requirements, some complex requirements. That increases litigation risk, right? But what are the next steps for federal agencies to really make the phase 2 rules a reality?
It's a great question. And what's interesting about the NEPA regulations, CEQ develops, I'll call it a model regulation, and then there are more than 80, it's close to 100 federal agencies that have their own NEPA procedures. Maybe not all of them will need to be revised, but that's something that agencies will certainly have to look at to see if there are changes that will need to be implemented. So one of the first things is agencies now are out there writing their revisions, their proposed rulemakings to conform to this new phase 2 rulemaking. There's proposals that I believe are required in September of next year. So I guess the phase 2 rulemaking, of course, is effective now. So after that effective date, it's really kind of the onus is on these project sponsors and these agencies to figure out, one, should agencies go back, comply with the phase 2 rulemaking. And I don't think in the CEQ rule, they required them for projects that are kind of on the way and under development to go back and do that. But I don't think they prohibited them from doing that either. So it's sort of this risk averse approach that if you're an agency, they'll probably take the most risk averse, the approach that gives them the most security. And that may mean going back, even if a project's already underway, to redo the analysis to match up with this rulemaking.
Yeah, as of July 1st, agencies are going to have, when the rule goes into effect, agencies are going to have to decide how to handle that. I mean, I think the key thing is that agencies should explain in their ultimate decision document which rule they were following and just why, so that it's clear in the record in the event that there's litigation challenging a permit on that basis.
So, Chad, thinking about what specific projects need to do, and you talked earlier about major investments. One of the things that we've all discussed over the past several months has been the FRA and its changes to NEPA. And regardless of the specifics of those changes, I think permitting reform aspects of the FRA had a thrust to them, right? Kind of the point, whether the statutory text fully accomplished this or not, was, hey, let's not do away with the permitting process. Let's not do away with environmental reviews, but let's create some predictability around the review process so that investors and companies have some sort of stable foundation for evaluating their own timelines and their own investments. Do you feel that this phase 2 rule sort of ignores that thrust that I'm talking about? Is there a legislative fix needed? Are we going to be having permitting reform part 2 discussions for the next few years?
It's a great question. And I think the phase 2 rulemaking will probably just invite more action on the Hill to actually address some of the delays. And the FRA really did have this thrust. And if you talk to and listen to Representative Garrett Graves, for example, who was one of the primary negotiators with the White House on those permitting provisions. And they were really trying to do something good to drive the permitting process to happen more quickly, getting agencies to work together on one project or one environmental document and one schedule. And the rulemaking could have beefed up these provisions and really driven some of those provisions harder. There are some pretty easy outs on some of those things, and they really could have pushed it a little bit harder to provide more accountability and to support that thrust that, look, we need more efficiency, we need more transparency and predictability for project sponsors and for agencies too.
It strikes me that there are two categories of litigation we're going to see in the wake of the phase 2 regulations. And I'd like to hear your thoughts on both of them. The first is sort of project specific. If, to be very reductionistic about it, NEPA phase 2 took us from 50 requirements to 100. There are 50 more, an increase of 100%, right? Little sticking points where an agency could have had a foot fault, where there could have been arguably arbitrary and capricious agency analysis and decision making. So that seems like a big risk area. How should projects be thinking about that as they shepherd their own projects through the review process, and what can be done about that? And Chad, thoughts?
Yeah, remember there might be two types of project-specific litigation, right? First, there's going to be the kind that threatens the permit viability because it's a challenge by folks who are opposed to the project and challenge the agency's compliance with NEPA. Then it's always possible that a prospective permittee, somebody who wants the federal authorization, may be denied that authorization, or the agency may propose mitigation measures that aren't viable. And so then there could be challenges by those folks alleging that the NEPA requirements, that analysis that preceded that, was overbroad and outside the realm of reasonableness in the statute. So there could be two kinds. Addressing the first, the challenges to the permits that folks need to build out infrastructure, other projects. Obviously, the key is always to work closely with the agency to make sure that the analysis is well done and addresses all the issues, because what you want the agency to have is a great administrative record, right? So under these new regulations, while some of the requirements may be problematic or troublesome for applicants on the one hand, on the other hand, you want the agency, if it's going to have to do that, to do a really good job so that ends up surviving litigation. I mean, you can look at one example in the phase 2 regulations with the changes to the alternatives analysis requirements. This new identification of the environmentally preferable alternative, it's not wholesale new to the regulations, but it's new in that CEQ now expects agencies to identify that environmentally preferable alternative while it's developing the alternatives. So I think that's a place where we're going to see potential challenges to specific projects in the future. But again, the key is developing the administrative record.
I think another place too is mitigation. I think what we've seen in the changes now that mitigation, if it's required, it's going to be enforceable. And I think previously mitigation may have been required where applicable, but now it seems like there's a lot more teeth to the mitigation requirements that I'm concerned that it's created this hook for litigation if the folks aren't meeting a certain threshold for mitigation that previously maybe it wasn't applicable, but now it is. And so I think there's going to be a lot of concern about that and potential litigation in that area as well.
And that, I think that in particular will be a really complicated set of legal challenges when you have CEQ directing another agency to require enforceable mitigation. That agency that has required that mitigation under a record of decision or something else, they may not have clear enforcement authority under their own organic statute. And so you're going to be really having some complicated legal challenges and complicated legal analyses that have to be done. I think there's going to be a lot of that. For some of these requirements, they raise not just questions about NEPA, but questions about other agencies' organic statutes. So I think that's going to be a real problem.
There are a whole suite of examples where, because you're adding new requirements, agencies haven't had the experience to go through and really figure out what exactly is going to be required. Public outreach, for example, which is important. not to downplay it, but there were just a lot of new requirements added into the rule, that choosing what level of public outreach is appropriate and what language and what medium to use, whether it's radio or written, and all these different things that agencies may not have sorted through or could set them up for other potential legal challenges because they just didn't do enough outreach. So when are these things going to be satisfied? And when these open, more subjective type requirements, it's hard to define what those, sort of boundaries are for what is acceptable and what's not, or not enough.
Personally, I'm watching out for a court decision that requires an agency to post on TikTok to make sure it's engaging the public.
I won't see
That's got to be out. Yeah, I know.
NEPA going mainstream. All right.
Absolutely. But then there's the whole TikTok ban thing. So that's totally different. Or maybe shouldn't have brought that up. But there is like a second kind of bucket or category of litigation over this new rule. And frankly, my neck is still sore from WOTUS related regulatory whiplash, right? One of the things we've talked about on this podcast and webinars, seminars, is the difficulty for lawyers, for the regulated community, for everybody to understand just in a particular moment in time, in a particular location, what requirements apply. And with WOTUS, we had the Clean Water Rule, and then the Trump administration pulled that back, and then it issued its own rule. And then, oh goodness, finally we have a little bit of breathing space after Sackett. But as I'm sure Ann will point out, there's still things going on with WOTUS.
Right.
And I guess my concern is that NEPA might sort of become that, because we've seen this litigate, elect, repeat kind of process.
Yeah. I mean, I think there's no doubt about that. In my mind, if Biden does not secure a second term, this phase 2 regulation is early up on the chopping block for sure in the Trump administration. And one might expect that they would go back to the regulation that was promulgated in the Trump administration or make some tweaks to that. Who knows? And in terms of litigating the rule, as you both are aware, there is a case pending that's been brought by a number of states to challenge the phase 2 rule. And that will be interesting to watch. I think plaintiffs have had difficulty, as we saw in the Fourth Circuit last time around, challenging the NEPA rule on its face for lack of standing, ripeness reasons. But the states in this case have pled very direct injury to themselves, especially in the transportation context, where some states have responsibility for conducting the NEPA process. So it will be interesting to see if that case survives a potential motion to dismiss, or if there is such a motion that will be filed. But I certainly think the election results will be very meaningful to the lifespan of this rule.
It will be, and it would be a major disappointment if NEPA were to continue to have this whiplash effect because of all the investments that need to be made. I mean, ultimately, if you were trying to transform the energy system and infrastructure and manufacturing, reshore all of this manufacturing back to the U.S., secure our supply chains, all of these sort of things, it takes long-term investments to make that happen. We're not talking 1 or 2 years or 4. It's 5, 10, 15, 20 and more years that we need to make these investments. So what project proponents and states and others really need is that predictability, and the flip-flops back and forth are not going to help that. So I ultimately think it really needs to be addressed through legislative action. Administratively, I don't see an end to it going back and forth, because if there's a change in party, they're going to have different policy goals, and they're going to want to implement that through regulatory policy changes. So it really begs for some type of legislative fix and some type of compromise where Democrats and Republicans get together and say, look, we need to build stuff. We need to build a lot of stuff. We need to build it quickly. Let's figure out how to do it.
Of course, we may also have the Supreme Court stepping in on some of these issues, since the Supreme Court has just accepted cert in the 7-county infrastructure case, NEPA case. I was surprised that they took that case, and it will be interesting, given their array of potential responses, to see how that ultimately plays out. But certainly it very directly sets up one of the key NEPA questions, which is the extent to which agencies need to analyze effects of their actions. In that case in particular, dealing with the STB's authorization of a rail line, that project opponents argue that the agency should have assessed all the oil and gas development that would occur as a result of the line, as well as the refining downstream. So that Supreme Court decision, unless they decide cert was improvidently granted, certainly could have very significant implications for NEPA and for the Phase 2 rule itself.
It's all starting to seem very sort of Marvel Cinematic Universe-y, isn't it? Where here we are at the end of a Supreme Court term with major environmental and administrative decisions, and we already have a preview of what the next term might include. And of course, we have an election going on, and so this is quite a bit to pay attention to. And it's so helpful to have both of you here to sort through it. And then Chad, especially you helping us to see the forest, helping us to see how these change regulations will have effects outside the courtroom, right? And outside an agency NEPA database, with dutiful public servants reviewing to make sure they're taking that hard look at environmental impact. So thank you for being with us as always, and have a good one.
Thanks, Daniel. Appreciate it. And it's an important issue, and I hope we can make some progress on it and get the stuff built we need to get built and protect the environment at the same time.
Thanks, Chad.
Thanks, Chad.